Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning. You may be seated. All right, good morning again. We are ready for our first case. And is it Ana Hernandez Gerardo versus Pamela Bondi? And first we'll hear from, is it Mr. Kirchman?
Yes, ma'am.
All right, we will hear from you first. Thank you.
Good morning, Eric Kirschman on behalf of the petitioner. This is a petition for review of the denial of a motion for reconsideration by the Board of Immigration Appeals. The issue we're doing is, we're asking review of, is the findings of whether it was a particularized social group. The board found that it wasn't a particularized social group because the group was defined by the harm that it was subjected to, so the whole circularity argument. But I think that they were wrong in that we have the case of the matter of ARCG, where they looked at, where the board found that a Guatemalan woman who was married, who could not leave her relationship, that qualified as a particularized social group.
Does it matter that she here, that Ms. Gerardo was not married? Does that make a difference in determining the PSG?
No, I don't think it makes a difference because it's a relationship, and whether you're married, whether you're not married, there are all sorts of different relationships, but it is a domestic relationship, and I think that's what, a marriage is just a domestic relationship formalized by law. Here we have an informal relationship, but it's still a domestic relationship nonetheless.
So with this principle, excuse me.
Go ahead.
I wanted to ask, what's the limiting principle on that concept? Is it any domestic relationship then? Is it a romantic domestic relationship? What's the limiting principle for us to?
I guess this would be similar to a romantic domestic relationship where the parties are in a romantic, intimate relationship.
Well, my question, you may not win ultimately on, you may or may not win. The thing that concerns me is the way the analysis was done. It seemed that it was a quick look at the PSG instead of giving a little more in-depth analysis to that. Is that what happened in this case?
Well, yeah, that's what I believe happened. They just saw the way it was defined and they didn't consider it any further because it wasn't artfully drawn the way it was presented.
What would you have the judge do in that case, in this case?
Well, I think they should look to see what really is going on and what is actually discussed. I mean, we had this surplusage of the what was it again? The El Salvadoran women who are continually sexually abused and tortured by gang members, resulting in severe psychological abuse and death to immediate family member and lack of protection from government and police. Now, I think what happens is because the people who are filing these PSGs are trying to encompass everything, and it causes problems because here, if you look, distill what this PSG was, it's a woman who was forced into a relationship. Then she agreed to it under duress. She agreed to enter into this relationship with this gang member. That it was fine for a while. Then it became abusive. And then when she attempted to leave it, he cut her with a knife, he hit her, he threatened her, and she goes to the police, and the police say, you just got to basically, I mean, they said it was nighttime, and that and that basically she just has to get used to it. She just has to accept it. So that was going to the police, that's what she got. So we have a situation where she enters into a relationship, happens to be with a gang member, not by her choice, and then it becomes abusive. So that's where we have the persecution of her, and she goes to the police, and the police will not assist her. So I think that would be a sufficient PSG if you, and what happened here is because I think all the extra on the PSG caused the BIA just to look at it and say, well, it's just circular, it's defined by the harm.
But how are you gonna, what's your best argument to get around the anti-circularity requirement? Because clearly, I think when you get into the discussion regarding the psychological abuse and the death of a immediate family member, it appears to be, circular as to the harm.
As to the harm, but I was reading more about the PSG, and it says it has to exist basically before the abuse. You have to be able to define it before abuse. And that's really what it is, because like you could say in the South during the Klan era, okay, so you have the black population that without harassment, a PSG is really not, I mean, even though they are a PSG, it's not relevant to anything. It only becomes relevant once they become subject to abuse and harassment. There you had the Klan, so you have it, so it's basically you have the group that exists independent of the abuse, and that's what we have here. We have a group of women in a relationship with a gang member.
So in the case that I believe we're talking about, Amaya Disakarian, that was a Fourth Circuit case that talked about the anti-circularity principle. And in that case, this court was relying on the BIA and the Attorney General. So my question is whether that case, given the overruling of Chevron, whether we are still bound by that decision and whether we still need to give deference to the BIA opinions at all in this case, post-Chevron.
Well, I don't think you have to, post-Chevron, I don't think you have to give deference. I guess they're instructive, but I don't think that the deference is required. But I mean, if the group exists independent of the abuse, and this group does exist independent of the abuse, because the circularity would be a group of people in El Salvador who are punched in the face. That would be circular because a group would be defined by being punched in the face. Here we have a group that exists independent of abuse. And I think that was the issue that was missed by the BIA, and that it should have looked at the group itself, and then the abuse is relevant because that's part of the persecution. And that's what happened here. I think.
What's the difference between I don't see how the abuse is separate from the group. The group, as I see it, is defined in your client's definition is El Salvadorian women who are continually sexually abused and tortured by gang members. Isn't that circular?
Well, that is, if you take it at its face, if you look a little deeper into it, it exists independent of that. I think it was artfully drawn.
What would be the independent group if you take the harm out? If you take, it would just be El Salvadorian women who
are in a relationship with a gang member, basically who can't leave. It's like the Guatemalan case where that woman couldn't leave her domestic relationship.
But I think in that case, don't they say it was because she was married, which is why I asked you the question in the beginning. I think they say they in that case it discusses the fact that she's married to him in societal norms because of the marriage.
Well, that was one thing because of the way that marriage is looked at in the Guatemalan culture. But I think you could have, because there are more than one way to have a domestic relationship, and one they look to see, because the laws for domestic violence, which is one of the factors you can look at to see if there is particularity of the group, and we have laws that protect people from domestic violence whether they're married or not.
Well, I think what's relevant is the laws in the country. in her country. And so is there any development in the record of these laws in the country that protect domestic relationships, or for example, of common law marriage, which I understand to be the case in many countries?
Well, we have the country conditions in the appendix, which sets forth the laws for domestic violence, and it goes through domestic violence in there. So that's why the society recognizes domestic violence outside of a marriage. So we are looking at something society does recognize. Otherwise, the domestic violence laws would be limited just to people in a marriage, and they aren't. So society does recognize this group as something that exists independent of the violence. I mean, yeah, we have a problem in that how our PSG was drawn, but I think if you look deeper in the PSG, you see what it really is. So I think we have a PSG there. We also have the second alternative PSG about rural El Salvadoran women, and they just said, well, who lack standing. The Board of Immigration Appeals said, well, it's not particular enough. Or it's not defined enough. What are rural El Salvadoran women? And I think rural has a very recognized definition.
But it's not an immutable characteristic.
Well, that would be true.
And doesn't our case law say that the PSG must be defined by an immutable characteristic?
Yes, that's correct.
And we're
It-
bound
it
by,
would lack the
and we are
immutable
bound by that
characteristic.
precedent.
Yes. So, yeah, that is an immutable characteristic because she can move.
And
But-
she did.
Yeah,
And
she
she
came
did.
here.
So my guess is that your argument is your first PSG is
Yes, so
probably
the
your
first,
strongest, is your
now that it's
strongest
been
one.
pointed out, yes,
Yes.
that is my argument. And then we also have the well-founded fear of persecution. I know the government's arguing that we didn't preserve that, I think it is preserved. Number one, in our brief, we said that this is a clear case, in the brief to the BIA, we said this is a clear case of domestic violence, which shows persecution. And even though it wasn't well argued in the motion for reconsideration, the board still, in its decision denying the reconsideration, addressed it. So it was addressed by the court, the board. So that would mean that it would be preserved for us. It's not a waived argument because it is addressed. And they say, well, there's no fear of persecution. But we have the past persecution. That was found. And a Ninth Circuit case says a person who has suffered a well-founded fear of persecution in the past is deemed to have a justifiable fear of future persecution unless the government shows by a preponderance of the evidence that conditions have changed in the alien's home country to such an extent that that fear of future persecution is no longer well-founded. Now, what's also interesting in this is she originally left El Salvador and came to the United States in 2014. Now, yes, we're at 2025, and we have this period of time where there's no contact or anything, but when do we measure it by? Can the government just delay a petition for years and then come back and say, well, nothing's happened in that time period, so any belief of a fear of persecution is just not founded anymore? And that's here. So we have 10 years because of the government, the government not having a final resolution of the case. Initially, when she came here, it was all very fresh. So we have 2014, 2015. 2014, I think, is the last abuse in El Salvador. She comes here, and then it just lingers, and the government wants to benefit from that by saying, well, because it took so long, you can't show that these people are still actively pursuing you. But she has a well-founded fear. She was a victim of the past persecution, And unless the government can rebut that if she returns, she would not be subject to it, then that's sufficient as a
Well,
fear of
did
persecution.
the BIA apply the presumption?
I didn't see it.
And your contention is they should have.
It should have applied a presumption because it did find the prior abuse. So 20 seconds, I don't have anything I can add in 20 seconds, so.
Any other questions? All right, thank you. You have
Okay.
reserved 5 minutes, so we'll have you back up shortly. All right, thank you. And it's Mr. Nelson.
Good morning. Aaron Nelson for the respondent, the Attorney General.
Yes, sir.
Your Honors, for petitioner to have succeeded on her motion to reconsider, she had to establish an error of fact or law in the Board of Immigration Appeals prior April 2023 decision. And we contend that she simply failed to do that. And I would like to start with first principles when we are discussing asylum cases that are anchored on proposed particular social groups. As the panel has already engaged petitioner's counsel, in addition to the immutability principle, the particularity principle, and the social distinction, what transcends all of the cognizability analysis on particular social groups is that the group cannot be defined by the harm to its putative members. And this is not a controversial, it's
Is
axiomatic.
any of that written in the text of the INA? Or is that all judge-made
I
law?
believe it's all law made by the Board of Immigration Appeals and by most of the circuits in the case law that I reviewed coming here.
And all of
including-
those cases were decided before Loper Bright, isn't that right?
Most of them would be, and in the case that Your Honor referred to, Sikaran, was decided before Loper Bright. But in reviewing that case, I read it as actually not only giving deference to under Chevron, but also offering its own analysis of particular social groups and standing on its own, on that analysis, such that the anti-circularity principle was affirmed there. And also.
But it's not in the text of the INA.
It's not in the text of the INA. And I would say with regard to.
So where does the INA itself support this anti-circularity principle? Where do we get that from the text of the statute?
So I would invite the court to review the seek our own decision, wherein it says that without the anti-circularity principle, the on account of requirement, we have these categories that an applicant has to anchor her asylum claim in, and she has to say that she was persecuted or has a well-founded fear of future persecution on account of one of these categories. And in Sikaron, the panel there said that without the anti-circularity principle in place, the on account of, or the nexus requirement becomes superfluous or a tautology. It would be like saying, I'm a member of a group of people who were persecuted in the past, therefore I should get asylum. It's this tautology. And I think that Seek Our Own and all of the, well, I shouldn't say all of the other circuits, but the decisions that rest on the idea that a definition cannot, the definition of a particular social group cannot be anchored in the harm to its members, it certainly survives Loper Bright. In the post-Chevron world that we're in, if we refer to, if we see in Loper Bright that the Supreme Court was making a prospective decision and directed that well-reasoned decisions would stand under stare decisis. And I believe that, for example, the Seek Our Own decision of this circuit found that the following particular social group was not cognizable, and that the petitioner there proposed married Salvadoran women in a controlling an abusive domestic relationship. And that was not cognizable because it was defined by the harm to the membership.
What about familial status? Can that constitute a particular social group?
So,
Members of a family, as your colleague suggests?
so petitioner's counsel, in his opening remarks, said, if you distill what this, her first particular social group was, if you distill this into what it really was, that's another way of asking the court to give her a second chance at defining the particular social group. Opposing counsel asks that the matter of AB decision by the previous Attorney General, which resurrected ARCG and its definition of a particular social group, is such that, in fact, in their opening brief, they say hers is no different, but we don't even need to do a deep textual analysis to see that in fact, it is different. So in the matter of AB, which resurrected that particular social group, that social group was married women in Guatemala who are unable to leave their relationship.
Isn't that what we have here?
No, here we have Salvadoran women who are continually sexually abused and tortured by gang members, resulting in severe psychological abuse and death to an immediate family member and lack protection from government and the police.
Mr. Kirschman brought up an interesting point that the country report recognizes domestic violence and it's not just limited, I believe, to married women. Does that make a difference in your argument?
Your Honor, no, it doesn't. We see cases that come from El Salvador and Central America in which the applicant has experienced abhorrent conduct. But in the asylum statute, it doesn't encompass every abhorrent conduct. And so whether or not the country conditions say that spousal abuse or domestic violence is a widespread problem, with respect to this case, that's an ancillary backdrop because the definition, if petitioner seems to have wanted to present a different particular social group definition, but as harsh as it may sound, she's stuck with the one that she presented in the first instance. And that is not controversial. Also in the Sikaran case, the Fourth Circuit, this circuit noted that the petitioner there tried to massage and offer new particular social group iterations in her petition for review, and Sikaran decision said that that was not allowable. And so, as harsh as it may sound, she is stuck with the definition that she presented, and that definition is suffused with harm to its putative members. And this anti-circularity principle is something that the government contends that she cannot get around. Are there any other questions?
I do have a question. Let's say she is able to, this court finds that her PSG is cognizable. On the fear of persecution, I wanted to hear from you regarding that, but particularly as to whether or not the BIA gave an explanation as required. Because it seems as if they...
With respect to the well-founded fear finding,
Yes.
Your Honor? So I think the board decision with respect to well-founded fear is circumspect, but part of the reason it's circumspect is because the board has to analyze the claims that are before it, and petitioner's claim to the board was effectively silent with regard to the well-founded fear. Now, to the extent that the board, circumspect though it may have been, engaged the well-founded fear, we would contend that petitioner has not shown an abuse of discretion on seeking reconsideration of that decision, even though it's circumspect, because underlying that, the board's decision on the merits found that there's just not an objectively reasonable indicia of evidence that her well-founded fear is anchored in the facts.
But they didn't, you would agree they did not give any explanation. They just said it's not. And the BIA did not provide any explanation as to why it was not.
It reaffirmed its prior decision, and in denying reconsideration, it's one sentence. But I would say, again, that's mostly because petitioner didn't present that in a full-fledged argument to the board. And with respect to the well-founded fear, it still is, I mean, I understand the predicate that Your Honor presented, which is assuming that somehow she's able to get over the hurdle of the anti-circularity. What happens to her well-founded fear? Well, I would reiterate that the well-founded fear still has to be anchored in one of the 5 categories for asylum, and her category that she chose is a particular social group. Again, where that fails, the well-founded fear fails. Nonetheless, the evidence that was reviewed and decided by the agency was that she left her hometown and went to the capital where she lived with her sister for several months. No one looked for her, no one harmed her. There's nothing in the record about menacing phone calls. There is one instance while she was away from her hometown where she testified that this gang member, her former boyfriend, his henchman came to visit her mother and said, she better come back and reignite or come back to the relationship with the gang member, or they will harm her. That was a one instance, and there's no evidence that they came a second time. She came to the United States, and now we're 11 years, and there's simply no evidence that this gang member continues to pursue her. Excuse me. And the other evidence with her saying that her father was killed, she's certain that, she believes, she's not certain, she believes that it was because of this former gang member, but there's no death certificate, there's no corroborating evidence, she just thinks that that's true. And the same evidence where she thinks that that's true, she also testified that in that time frame, lots of mothers and fathers and brothers were unfortunately, in her area, were unfortunately murdered by nefarious characters. So we would say that that survives the objectively reasonable component.
Yes, but I guess my concern is just that the BIA did not give us any reasoning to review. They just said, I think the exact words are, she failed to establish a well-founded fear of persecution. And they gave no further reasoning as to how they arrived at the conclusion.
So you're in the denial of reconsideration, although that's the only decision before the court in the petition, there, necessarily we have to sort of take a peek at the merits decision, and I believe the merits decision, the two are linked. In the merits decision, the board says, we also uphold the immigration judge finding that the respondent did not establish a well-founded fear of persecution, considering the gang members apparently made no effort to locate the respondent when she went to live with her sister, the lack of evidence to support her belief that the gang members killed her father, et cetera, et cetera. It goes through the record at 22, I believe the third paragraph. So because the two decisions, you have to take a peek at the prior decision, it's sort of incorporated by reference, I would believe, because she's asking for reconsideration of the prior decision. You made an error in the prior decision, and I certainly take your point that the board's denial of reconsideration on well-founded fear was just that sentence, but because it has to look back at its prior decision, I believe that that's incorporated, and I believe there's enough there to support its decision.
Thank you.
If there are no further questions,
All right, thank you.
thank you very much.
begin with, there was one additional incident after, about the gang members threatening the petitioner, and then after she was detained in the United States, that fact was communicated to her mother by the gang members. So they knew, so they had some evidence of knowing where she was. And I think with the PSG, what is telling that this is a group recognized in El Salvadorian society is the statement made by the police when she went there, where, well, they said, there is nothing we can help you with, and what you just told us is completely normal. You just should not give it any attention. Now, that's recognizing her in a specific category of people because they're telling her it's completely normal. Now, would they have done that if it was just somebody on the street who had been cut by a gang member? So I think this statement by the police is recognition of the PSG in this case. And I would submit on that and ask that the order of the BIA be vacated. Thank you.
Thank you. Any other questions? Thank you.
Okay, thank you.
All right, thank you, council. At this time, we will come down and shake your hands. Just for, by way of information,
recorded calls. Those are identified by the Capital One records. And then who had the call at a given point in time can be determined by the carrier records and Capital One's designations of wrong person, right number, wrong person. The reason there is
So you would just be relying solely upon the records from Capital One? I'm trying to, if you're saying you don't need an expert.
Capital One and the carriers, and the reassigned number database, a subpoena to them to determine the dates of disconnect. This is simply a process of who had the phone number at the time of these pre-recorded calls, right? So if you can determine who they were calling, in this case, they were trying to get a person, I will call him E.T. to leave his name out of the record, but, and they got Mr. Davis because the phone number had been disconnected and transferred to Mr. Davis. The reason we have the expert and the reason the expert was presented is this is a person who does this on a regular basis. So they can do it faster, better, easier, but it is not required for that expert to be the one who does this analysis.
But perhaps where I'm struggling is you need to have to be able to, in order to define the class, you have to be able to say a methodology, and there has to be somebody that's going to testify as to that methodology. And where I'm struggling here is that your expert didn't present a methodology that was actually proven. It was a theoretical methodology. And so how is the court to find that all of the 4 requirements of 702 were met? Are you
Well-
suggesting that 702 doesn't apply to this to this expert, or just Daubert?
I would suggest that 702 does apply. And the
And
court.
so the 4th prong is that the expert's opinion reflects a reliable application of the principles and methods of the fact, and methods to the facts of this case. So how is the district court to determine whether that 4th prong was met here?
The district court looked at part of her analysis. That was the problem. First, it used too rigid a standard under 702. This court has said many times that 702 is to be liberally construed. This is not a trial of fact-finding. It is a preliminary stage of the process. But the court ignored subpoenas to the carriers. The court ignored the wrong number designation in Capital One's record. The court ignored a subpoena to the R&D in its analysis. So it focused on a subpart of the analysis instead of focusing on the entire process that the expert
Well,
presented.
I don't know if the court ignored it. I think your expert said that she didn't run the full methodology because of financials, and that's why she didn't go on the sample. She had a sample 5,666. She said, I didn't take the next step getting the subpoenas because of the financial strain or restrictions or something.
That was part of her reasoning, Your Honor, but if there's no class has been certified at this point in time, right? So the court could change the class definition as we go along. And that's why it is really the temporal aspect of the ascertainability standard that has not really been made clear by this circuit. It's basically said at some point in time. At some point in time cannot be the class certification point in time, or you wouldn't say then at some point in time. And if you look at the Krakauer case, which is very, very similar in almost every respect to this case, there was a review of ascertainability at the class certification stage. There was a review of ascertainability at the class notice stage. There was a review of ascertainability at the trial stage, and there was a review of ascertainability post-trial. So this is not a set in stone, you must prove this. Certainly this court has never said that. You must prove this at the class certification stage.
But in that case, that was different because that was the do not call registry, right? And so you have people that signed up and said, do not call me, and then they were contacted.
That's correct.
Which is a little bit different here. I mean, because you had the numbers, and then you could just go look at the database and see who was contacted. Whereas here, you got this consent element, like who consented. I mean, they didn't have that in that case, and I think that's the difference in that case than the one here. You got this element of consent. So, I mean, could have a work phone, And so based on the methodology that, I think what you're saying is I can go this reverse, I think, opinion of looking at numbers, you can go back and see who owns the phone. But
yes, Your Honor.
if it's my work phone, or if my spouse has the phone in their name, how are you gonna know who consented and who's not? I mean, it seems like you would have to go through it individually and look at it.
No, if I may go back, consent is a part and was a part of the Krakauer case. And if you read what the Krakauer court said about consent, it said the defendant's records are going to show whether somebody consented. It's actually probably a higher level of consent inquiry than in our case, because we have defined the case as non-customers. If you have non-customers, those people by definition have not given consent. As far as your other question, the issue of who had the phone can be determined by the records. If you look at Mr. Davis's phone records, it showed Mr. E.T. had the phone till this date, Mr. Davis took it over on this date. The Capital One records show there were calls made to that phone number after the date Mr.
But
Davis took it over.
that's Mr. Davis. A class action is a mechanism where a group of people all have the same characteristics or some common characteristic, and they come together. Where I think your argument falls short is that your client had this particular story with his cell phone, and the experts testified that the way he was ascertained isn't the same as you would ascertain another member of the class. Even when you began, you gave a whole bunch of different mechanisms that we sort of had to look to together and somehow pile them together to create a class, and that seems to me not feasible, frankly.
Your Honor, if I may, and I'm saying I'm out of time, may I
Yes, sir,
finish?
you can, yes, sir.
The class is people who got pre-recorded calls from Capital One without consent.
I understand. I think what we're
Under
struggling with is how we figure out who is in that class. But
Yeah.
I think you have time on,
Yes,
Yeah.
you have
thank
7
you.
minutes reserved. Yes, sir, Mr. Hubbard.
Good morning.
Good morning.
May it please the court. Capital One has perhaps one main point that we'd like to make in response to this appeal, and that is that the trial court did not deal in hypotheticals. The trial court's decision was directly drawn from a extensive record of documents and based the decision on sworn testimony and those documents. Just like any other class action, the appellant in this case had to meet their burden to show that the claims were appropriate for class certification under Rule 23. They made a strategic decision to meet this burden based solely upon the testimony of the expert opinion of Ms. Verkovskaya, even though Ms. Verkovskaya repeatedly said in her deposition that ascertaining or identifying class members was beyond the scope of her retention. On the appeal, the appellant must show that the trial court abused its discretion by making a legal error or basing its decisions on a clearly erroneous factual finding. And we believe that they can do neither.
How are the claims in this case different from the Krakauer case?
Yes, well, as the court as the court noted, the Krakauer case is different, and I would draw the court's attention. Capital One actually addressed this in the briefing below in the motion to exclude, and I would draw the court's attention to the joint appendix at 253. There is a chart, a table that Capital One created where we listed out the steps of the methodology that Ms. Verkovskaya used in Krakauer on one side, and then compare the methodology proposed in this case on the other. And not a single step matched. And there's good reason for that, because as the court has already noted, the Krakauer case it's a TCPA case, but it was under a different section of the TCPA. It was brought under section 227C for violation of the do not call registry. And in that case, the defendant's agent had made telemarketing calls to a list of phone numbers from one of their competitors' customers. And so from that starting point alone, you have a defendant who has no consent to call those telephone numbers. And so based on those facts, the court ruled that the class in Krakauer was readily identifiable by comparing the do not call registry with the aggregate records of the defendant. That list included the class members. This is different in our case, and our position is wrong number TCPA cases like this are just simply different from that. And in fact, I mean, in Krakauer, again, you start from the premise of the defendant lacked consent to do telemarketing. Capital One's not a telemarketer. The evidence showed that it only makes calls to telephone numbers for which that associate with an account. And so it's not a telemarketer. So in this case, contrary to Krakauer, we start with the premise, well, the evidence showed Capital One had consent, believed it had consent or had consented at a certain time to call all of the numbers. And the trick here for the appellant would be to provide a reliable methodology to figure out, well, which ones don't have consent, and do so in a way that's appropriate as a class.
Well,
where
you concede that you didn't have consent to call Mr. Davis, isn't that right?
There's no dispute that Mr. Davis, the evidence showed Mr. Davis was not a customer, and Capital One did not have consent to call Mr. Davis's telephone number.
So it's
yes.
not the case that you had, I mean, you just said that you had consent to call all these, you believe you had consent to call all these numbers, but in fact, you're aware that you didn't have consent to call Mr. Davis.
Yes, and I should correct that. At the time that Capital One was calling the telephone number, the 8329 number at issue with Mr. Davis, Capital One believed that it had consent, and that's what I mean.
And during the class period, what mechanism did Capital One take to ensure that it actually had consent to call all of these numbers? Did Capital One check, for example, the RNC database during that time period to make sure that it actually had continued consent to call all of these numbers?
So the evidence indicated that Capital One does not use the R&D, the FCC's R&D database.
Yep.
But
It doesn't use it even to this day? I understood that it does use it now.
No, Your Honor, there's no evidence for that. What the evidence did show was that Capital One uses a private vendor that develops a scoring mechanism for essentially the likelihood of associating those telephone numbers on a forward-going basis. And, you know, this is in the testimony from Capital One's representative, they would contend that private vendor provides a service that is better than the R&D's service. That's what the actual evidence showed. So Capital One has no desire to contact non-customers in this way or leave voicemail messages where they don't have consent. They're not, so they do endeavor to avoid violations of the TCPA like this. So there is a system, at least a system in place for as long as they're making telephone calls.
So could we talk about the expert for a minute?
Yes.
So she's testified as an expert and qualified as an expert in, I understand, over 1,000 cases, is that right?
That was her testimony.
Yes, and so, and my understanding is that at least below, what she said was that she didn't follow through on the entirety of her analysis at the class certification stage, is that going through the entirety of the analysis would be too expensive and too onerous. So she, I guess, went through the first 2 steps, showed how they narrowed the pool, but then didn't carry out the final 2 steps. So, and what the district court found was that then, because she didn't go through the entirety of her analysis, that she was not qualified. Is that right? Is that what happened?
The district court did note that she did not apply her analysis. It's our position that the appellant wants to push that a little bit further than what the district court actually ruled. The district court, the appellant is claiming that the district court abused its discretion, and one of those ways was applying an incorrect standard of ascertainability by requiring the appellant to identify all the class members or fully conduct her methodology. But the district court didn't say that, and it's demonstrably incorrect. In the opinion, the court's opinion, the court ruled Davis, quote, "need not be able to identify every class member at the time of certification." That's in the opinion at the Joint Appendix 675. What the trial court ruled was that, just like any other class action, the appellant needed to provide a methodology that would produce, that was reliable. And
And is it your opinion that methodology had to be performed in full?
It's not our opinion that it had to be performed in full, but when it was performed, the undisputed facts indicated that it contained numerous errors along every single step of the way. Capital One, and this is, Capital One retained its own expert that performed steps of the analysis as well and demonstrated that the results were contrary to what Ms. Verkovskaya predicted. But it's not just Capital One's expert. There was sworn declarations from the administrator for the R&D, Ms. Beth Sprague, and she testified that contrary to what Ms. Verkovskaya said, the R&D does not provide a disconnection date, which was a big part of Ms. Verkovskaya's testimony. She further said you can't use the R&D like this. Additionally, Ms. Verkovskaya, she had to have a licensed vendor to run searches through the R&D, and that licensed vendor was Pacific East. Pacific East, the chief operating officer for Pacific East, Scott Rice, he submitted a declaration where he said, no, the R&D does not provide a disconnection date and can't be used to, you can't backdoor it either. You'd have to.
Usually all of this weighing goes to the weight of the evidence and not whether it's admitted in the first place. The arguments you're making are great arguments for why her analysis isn't as good as your experts. It doesn't seem to go to whether or not she's admitted as an expert in the first place, whether her analysis will even be considered. Here, that the district court didn't even admit it and disqualified her as an expert. And what you're really getting to is looking at the analysis and comparing the analysis of your experts versus hers. The sort of war of the experts was never even allowed to happen here.
Well, Your Honor, I'd say that this court has repeatedly held, including in the Sardis case, that the trial court serves a very important gatekeeper function to ensure the exclusion of unreliable and irrelevant expert opinions. And here, every time.
You can't say this is irrelevant.
Well, if she testifies repeatedly that she has nothing to do with identifying class members, and then, I mean, I don't know what irrelevance is. I mean, as a practical matter, classes are certified, we have class administrators all the time. I'm not sure why a class administrator would be coming in as an expert in the first place. Now, the trial court ultimately held, look, the appellant is basing their entire motion on Ms. Verkovskaya's method, so the trial court disagreed and assumed that it was relevant to the discussion here. But what happened was, based upon the facts, her methods were shown to be unreliable, and not just, I would say this is not a battle of the experts, for example, trying to set the industry standard of reasonableness, for example, and then you have someone disagrees with that. This is where a purported expert comes in and says many things about several different steps, 4 different main steps here, and each one of those had multiple errors within it. If there is any reliability requirement under 702, Ms. Verkovskaya, based upon the actual facts testimony in the case, Ms. Verkovskaya didn't come close to showing any reliability. And we believe that that's where the trial court that's what the trial court was getting at.
Do you believe that the plaintiffs have to have an expert in this case?
I don't think that they need to have an expert, but obviously for class certification, they have to meet the requirements under Rule 23. And this is the way, they have that burden, and this is the way that they chose to do this. we deposed Ms. Verkovskaya. And I asked her, I did ask her, well, why are you here? If this is just, you're relying on vendors to run searches, what do you bring into this? And she said in her testimony that only she could run this. So, and we've heard today that, well, actually, the attorneys could run it, but this is part of the kind of moving target of Ms. Verkovskaya and the arguments as well. But it's not clear to me, frankly, most of it was just paying vendors. We went and spoke to the vendors, and they said, you can't use our services for what you're saying you're using them for.
And your expert's opinion was admitted without objection, is that correct?
There was no objection, yes. We would say, ultimately, the appellant argues that the judge came to the wrong decision on Ms. Verkovskaya, but one of the ways that the best way to illustrate the errors in her proposed methodology is by applying them to Mr. Davis himself. And here the trial court did note that her own method, that Verkovskaya's methodology actually did not pick up Mr. Davis. And we can just walk through the steps very quickly. The R&D just simply, well, it didn't provide the disconnection date. So contrary to Ms. Verkovskaya's testimony, it can't do that. That's according to the administrator, Verkovskaya's own vendor, and our expert. The R&D did return disconnected for the telephone number, but it said disconnected for the time period prior to Mr. Davis having that number, during the time he had that number, and after the time. He only had it for about a month. So disconnected is not a reliable indicator of class status if you're identifying our customer, Mr. Davis, and then perhaps someone else that was never called.
No, go ahead.
But I believe one of what she said is that she has a second step, which would be the subpoenas. Would that, even though she was not able to answer the questions, I believe, regarding the process of the subpoenas, but would a subpoena process as to the carrier clarify any of that?
So the subpoena process is very interesting. So on a class basis, you would be dealing with a truly, what we would say, Herculean, monumental, a large amount of information. And I think, again, the method was changing throughout the briefing and arguments. But by the end of it, I believe that at the oral argument for class certification, the plan was to, I think they just said, they got to a point of just subpoenaing 14.9 million unique telephone numbers from an unknown amount of carriers, I guess, in the United States. This could be dozens and dozens and dozens. So that we would submit would be not feasible for class administration. Now, again.
Can you address the issue of, because you don't have a lot of time, can we just assume that the exclusion of the expert was erroneous and ascertainability is satisfied? Can you address the predominance issue?
Yes. So the predominance issue came down to, as the trial court ruled, that it came down to the issue of consent, and that there was no way to develop a common question to get a common response on the consent issue. In the appeal, the appellant argues that it's very easy to solve. They just, with their definition, they just said non-customers. But the trial court correctly rejected that argument. This is a semantics type of argument. You can either call it non-customers or people who didn't give consent. It's a distinction without a difference. You're going to run into the same problems with the methodology that they proposed that we've covered over and over again. So that wouldn't solve their problems. And then I believe the only other argument on appeal that they've made is that, well, they point back to Ms. Verkovskaya's methodology again. And as we've indicated, there are several problems with that. With regard to the subpoena, Ms. Verkovskaya never issued a subpoena on Mr. Davis either. It was actually Capital One. We subpoenaed the cell phone carrier T-Mobile. They eventually produced documents after requiring a court order to do so. As the court correctly noted, that would be an additional issue. When we got the response from T-Mobile, they indicated that the subscriber was not Mr. Davis. Instead, it was a Kyle Devon, which was a pseudonym created by Mr. Davis that he gave the telephone company to, for whatever reason, conceal any association with the telephone. So right there, you're even still getting to a review. And the response itself was a review that would involve at some point some sort of judgment call, I guess, from Ms. Verkovskaya. The response from T-Mobile was 92,000 lines long. So what we're talking about would be a subpoena process to almost 15 million unique telephone numbers to any cell phone carriers. All that's going to come in. We're going to have, I mean, you're getting into numbers that I can't do in my head, unless the court has any further questions.
Any questions? No further questions. Thank you.
Thank you.
Yes, sir.
Your Honor, I'd like to address some of the points that have been raised by Mr. Hubbard earlier on. I'd like to point this court to the decision made by the Middle District of North Carolina on February 18th, 2025, in the case of Stark versus Blue Cross of North Carolina. That was a wrong number case that was just recently decided. And there, the court held that the class's members are readily identifiable. The class is defined by objective criteria, whether consumers' phone numbers appeared in defendants' call records and whether they were Blue Cross customers. The court went on to say any other remaining class members were readily identifiable upon production of records and evidence linking them to the relevant phone numbers. I would submit to you that that is the now that was a settlement class, I will say that as we go forward, but the standard of ascertainability is the same. The amount of records needed to be reviewed is not a relevant criteria. This court has held dozens of times that it is not the amount of information that is required to be reviewed that is at issue. It is whether or not the records and information that is identified can answer the objective criteria in a yes or no manner.
Was the case you just cited in your briefs?
It wasn't, because it was decided just
Did you
4
file a
weeks ago.
28J letter with
Did
that
not.
case?
We did not, Your Honor. It was literally just decided a few weeks ago.
And you didn't provide it to your opposing counsel prior to argument?
I did not, Your Honor. Did not. But I think the decision and other decisions, if you look at the decisions made by this court and even the lower courts, apply these standards in a very haphazard kind of way. There's no consistency. And I would submit to you that if you look at how Judge Trenga applied these standards, it is much more rigid than any other court or any of the Fourth Circuit decisions permit. If we ask about this expert exclusion, and I think Judge Berner is absolutely correct, the issue is not whether or not this expert should be excluded because some other expert disagrees with them. If that were the case, every expert would be excluded in every case because there's always two experts on either side of the case, and one says one thing and one says the other. Experts are not supposed to be excluded unless they are really coming forth with junk science.
So I think, putting that aside, she's relying on in the methodology, she says she's relying on the R&D. And the director of the R&D says that the disconnect dates are not publicly accessible through the R&D public query. And then the other problem that you have is the director of Pacific East, which she says she's gonna use as reverse phone append. says that this is not reliable. So that's not relying on, that, the expert that they presented. That's the relying, in order for her to do the methodology or use the methodology that she's proposing, she's saying, I'm gonna use the R&D and then I'm gonna use the Pacific East. But they're saying that it's not reliable. It's not ascertainable and it's not reliable.
Well, I would politely correct the court's position that they said it's not available or it's not, they said in the public interface,
Yes.
it's not available. But the R&D is a list. All it is a list of disconnected phone numbers. That's all the R&D is, and that's what Beth
But it
Sprague.
won't tell you when it was disconnected.
It will tell you, it won't tell you on the public interface, but they have those records which can be subpoenaed. And they come from carrier records, and Mr. Hubbard referenced the T-Mobile records in this case. The T-Mobile records indicated the date of disconnect from Mr. E.T. and the date that Mr. Davis became the owner and user of that telephone. It's exactly as Ms. Verkaskaya testified would be used to do it. And the R&D was one piece of this identification methodology. If you took out the
But
R&D
that's-
completely.
And I guess the other problem you have is that it's incomplete, because your class period is the 4 years, and this R&D doesn't come into full existence, I think, until like October or November of '21. So
Correct.
you're missing 2 years of your class period, so it's incomplete.
Well, it's only incomplete if that was our sole basis of determining these numbers. The carrier subpoenas are not limited in that time frame, and the carriers are the ones that provide the information to the R&D. So a subpoena to the carrier for records before that period of time would indicate the dates of disconnect. It's not as clean because the R&D is simple. The reason we just chose to use the R&D is it is one place where the dates of disconnect are the only thing they have. That's what they have. But the carrier records, and Mr. Davis's records indicate this, do indicate the dates of disconnect and who got the phone number afterwards.
So how are you gonna identify the carrier though? Through your reverse phone append? I mean, are you just gonna?
The carrier can be determined through the phone numbers, and there's a process that you know, the claims administrators use to do this. This is not a unique thing to the TCPA or wrong number cases. In every case, someone has to be determined who has the violation or might have the
But in
violation.
every other case, there's not a class certified, right? You're suggesting that there's a methodology for an entire class, not an individual.
Yes, but if it works for the individual, it by definition works for the class, right? It's a process where once you have these telephone numbers, you simply subpoena the carriers, you see the date that the person had the phone that they were trying to call, and this, let's say Mr. E.T., and you see the phone number and the person who had it after that. And if there were pre-recorded calls to that person after the date they got the phone.
I understand, but for
then-
each person, there's going to be a different carrier, a different time, a different story, and that's,
Well, but that can be true in securities cases. You have to determine who had the stock, when they had it, when they bought it, what the, you know, this is not unique to a TCPA case or a wrong number case. It's a different application, but it occurs in every class case because you have to determine at some point whether the person is in the class and whether they're entitled to recover.
All right. Any other questions? Thank you.
Thank you.
All right, we will, thank you, counsel. We will step down and greet you, and remember Judge Floyd's up here after Judge Berner. you.
I like the way you run the show. I like the way you run the show.
All right, you may be seated. All right, our final case for the day is 24-1468 Travelers Casualty versus Jailwin Holding. And for appellant, we have Mr., is it Farnell? Farnell and Mr. Judge. All right, yes, sir.
Good morning.
Morning.
May it please the court, Mike Farnell appearing today for Gary Michael, Brooks Millard, Kirk Hashigian, Mark Beck, and Geldwen Holding, Inc. This is another in a long line of so-called related claim insurance coverage disputes in which the question is whether successive lawsuits against an insured are sufficiently alike that they ought to be deemed one and the same claim dated back to the first lawsuit, thus absolving the insurance carrier of its coverage obligation.
Well, how are we to define the common nexus?
Common nexus, again, under North Carolina law, we would look to its ordinary meaning because that phrase or term is not defined in the policy. Common nexus means a shared interconnection, some sort of mutual connection. And when you read that in context, Your Honor, it is in this litany of words that includes causally connected causes. We've got an exclusionary language here that is all at once this big and purportedly this big. And it's that at the same time, if Travelers is to be believed. Here, when you're talking about causally connected causes or anything that speaks to a causal interconnection, and we're dealing with antitrust litigation backwards in time beginning in 2012, and then we've got this later 2020 securities action. You cannot have a causal interconnection between an antitrust claim, which is, as the court knows well, a alleged conspiracy to restrain trade, and a securities violation, which is an alleged misrepresentation, in this case under the Securities Exchange Act of 1934. So we have this kind of fundamental threshold that we have to get past here, which is, can these things be deemed sufficiently alike when they can't cause one another? And one of the things that Travelers said in the briefing was that the antitrust allegations were a predicate for the securities violations. But that's not true, because if one assumes that all of the representations about the pending antitrust litigation were accurate, there couldn't have been a securities claim. It requires an intervening alleged wrongful act to create securities liability. Otherwise, it can't exist. And one of the real problems here is that we've got 4 human beings who have been sued jointly and severally for millions and millions and millions of dollars worth of personal liability. They have never been sued before. This is their first lawsuit. If an executive of a publicly held company who has no choice but to answer questions of investors and analysts, if that executive is asked to comment on prior or pending litigation, under Travelers' view of the world, that executive will always be uninsured because the answer will always merge back in to the prior litigation the comment is about.
Was the insurer given notice of the first antitrust action back in 2016?
There was no notice back in 2016.
Does that make any difference?
I'm sorry?
Does that make any difference?
Well, no, I don't. The point here, I think, Your Honor, is that what Travelers has done is focus primarily on a preceding claim exclusion. And the argument is not that it went back to 2018, 2019, or 2016, just that it wasn't Travelers. It just predates. It predates at some point in time prior to Travelers' policy period. And one of the reasons why I think your question, it raises a very good issue is because there was an argument below that the first 4 insurers, all of whom agree with these insureds' interpretation of these exclusions, Arch, the primary carrier who authored the provision at issue, AIG, XL, and Star, $40 million worth of claim decisions and actual claim payments. They all agree that this is a covered loss in the 2020 period. The argument below was that it didn't really matter to them. It was 6 to 1, half a dozen to the other. They were going to pay their $40 million in one period or the other. But what's forgotten in that, the reason that's not accurate, is because they could have taken the position that it dated back to 2016, as Your Honor notes. That was the first antitrust piece of litigation under the Clayton Act. These carriers could have, but did not. And that would have been a self-interested determination because I don't think they were I know they weren't in the tower back in 2016, certainly not in any similar order. So it is telling that under North Carolina law, we have to be anchored by these principles of insurance coverage, insurance policy interpretation. It's the only way we can really find our way through the morass of words like this. And under North Carolina law, the question is whether the insureds have proffered a reasonable interpretation of policy language.
Well, looking at the at Travelers' language, it's pretty broadly, interrelated wrongful acts that's pretty in their policies is pretty broadly defined, isn't it?
It's defined in the way that I have described earlier. It is defined with a litany of words, and that litany of words includes things like in any way related to. It uses the word interrelated and the word related at the same time in the same provision, defining one but not defining the other. And we will freely concede that there is an interpretation of this exclusionary language that is exceptionally broad. And that's the problem with all related claim cases. It's all about perspective. Are you looking at this from 10 feet, from 1,000 feet, or from 10,000 feet? Because the answer is different depending on how granular you are.
Is there a case that you can cite to in North Carolina or in the Fourth Circuit that says this particular language is ambiguous? I think what you're arguing is it's ambiguous and therefore we construe it against the insurance company. Is that right?
That's correct.
And so this particular language, does it appear in any case and has it been found to be ambiguous? Because it does seem to be incredibly broad and the words are pretty clear.
The one thing I'll say to sort of set the stage here is that under North Carolina law, the grant of coverage is construed liberally, broadly in favor of the...
I understand.
To answer Your Honor's question, we've pointed to the Town of Moxville decision, which itself contains both the term interrelated and the term related in the same policy. The court there went through the analysis,
But
found...
in that case, the exclusion, the word, and I know which case you're referring to, where the court said you defined related, but you didn't define in the policy, but not in the provision, you didn't define interrelated, and that's why the court said that there was a problem in terms of it being ambiguous. But here it's a little bit different because they do define interrelated. And in that provision where the exclusion is, I think it says, all claims for the same wrongful act, any interrelated wrongful acts, or the same or related facts, circumstances, or situations shall be deemed to be a single claim. So how is that not different because it's in the exclusion, it's specifically in this exclusion, and then it defines what interrelated wrongful acts are?
But it does not define related. So in Town of Moxville...
But related is not in that, is not in the exclusion provision. It's in the policy.
It is. No, it's in the exclusion. The term related, or in any way related, related facts or circumstances. That's the problem with the way it's drafted. It's a garden salad exclusion, which says interrelated wrongful acts means this collection of things, common nexus of causally connected causes, among other things. And then after all that, it says related facts or circumstances, situations, or events. It's got everything in it together. And so I really would commend to the court's reading Town of Moxville, which has this same problem, but just the inverse. Related is defined there, but interrelated is not. But the problem is the same, which is if we have these competing standards in the same exclusion, what do we do with that? Okay? Now, I would submit to the court that there is one straight line answer that avoids the problem that has plagued court after court after court in trying to bring reason to these exceptionally undefined and malleable exclusionary provisions, and that is the district court and travelers introduced this Highwoods decision, which is an Eighth Circuit decision that applies North Carolina law.
And you agree, we have not adopted that decision.
I understand. I
Yes.
understand. The point, though, is that as a textual matter, that court went through the analysis. When you're talking about the question of whether one lawsuit later in time should be merged back and joined with a lawsuit later in time, we're looking at the policy in effect during 2020. Okay? That's the policy we're reading and applying. In order to have a related claim analysis, we have to have two claims, and that's a defined term. Okay? If you don't have claims to compare, then there isn't a preceding claim analysis to undertake. A claim against a human being needs to be a claim against that director and officer. Let's not forget this is a $90 million tower of directors and officers insurance coverage. These folks have never been sued before. There was no claim against them. Only a dedicated securities claim coverage is the only coverage available to a publicly traded company. They're not covered for antitrust wrongful acts. They are covered for securities claims only. Before 2020, there was no securities claim. So the question is, was there any other claim to compare at all? If there was no claim against any executive, and there was no securities claim against the organization, there was no claim at all, and we never have to get into this morass of what to do with an exclusion so vaguely drafted.
So are you saying that you're asking us to make a general rule that securities and antitrust claims are not related? Is that what you're asking us to do, or are you basing your argument on the particular claims in this case?
What I am suggesting to the court is that the related claim analysis is never undertaken in the first place because there are not two claims to compare to one another. That's threshold
So
determination.
you're saying that no two claims, but they're different legal causes of action, can ever be related? What if it was a tort claim, for example?
What I am suggesting is that in a securities claim, when we're talking about dedicated securities claim coverage, if we're going to get into the analysis, what does that director and officer do? The question under a securities cause of action is the fact of the misrepresentation to prospective investors. What Travelers wants to do is to convert that into the substance of the misrepresentation. And again, what that will do to dedicated, purchased, sold, marketed securities claim coverage is that the minute that that executive answers an analyst's question about a prior claim, according to Travelers, it will always merge into that prior claim. It vitiates this securities claim coverage. It will always become something else.
Well, under this language, but the contract could be, the coverage could be drafted differently. But under this particular language, that's the argument. It's very broad.
The argument is that it is both narrow and broad at the same time. We have to give meaning to all of the words in the exclusion if we can. Common nexus means causal interconnection. We go to the dictionary and we look up terms in the dictionary when phrases or terms are undefined in the policy. Here, a connection of causes means that as narrowly construed, which North Carolina law requires, the question is whether the antitrust conduct, that alleged conduct, could give rise to a securities violation. Conversely, could the securities wrongful act, the alleged misrepresentation here, give rise to antitrust liability?
Well, so my understanding is, I think it's in one of the suits, I think it's a direct purchaser suit. Isn't that the argument is that the officers and directors were were responsible, even though they're not named, but the allegations of liability were against the officers and directors?
No.
So the complaint does not allege that the officers and directors were liable for the information that they were.
No, in fact, the antitrust allegations don't sue anybody, as Your Honor notices, but the allegations against the individuals giving rise to the alleged antitrust violations were a completely different group of people. They were the former executives of Masonite who also worked for Geldwin. That was the good old boys network referenced in all of those antitrust allegations. These 4 individuals are not named in those antitrust allegations.
And who are
save
the 4 individuals you're referring to?
Mark Beck, Kirk Hashigian, Brooks Millard, and Gary Michael. Kirk Hashigian is mentioned in the first 2016 Clayton Act case. The other 3 are mentioned nowhere. And that is, again, critical because we talk about reasonable expectations under North Carolina law. And 3 months ago, the North Carolina Supreme Court issued a very, very significant decision in North State Deli, which we cited to the court in a memorandum of supplemental authorities. And that court, it emphasized that when you have slippery, undefined, malleable terms, it's up to the insurance company to draft more clearly. It's not for the court to try to bring order to a textual word salad. Here, again, there is 3 separate, I can see I'm out of time, I'll finish my answer. There are 3 separate insuring agreements in this policy, what we call Side A, Side B, and Side C. The first 2 of those are for the individual directors and officers, claims against them, and the third is the claim against the organization, which is, again, just this dedicated securities claim coverage. The individuals are entitled to their own coverage determination.
All right, thank you. Oh, I'm sorry.
I don't recall that you answered Judge Berner's question about, is the language ambiguous?
We believe that it has to at least be ambiguous. The question under North Carolina law,
What does that mean?
that means that either as written or as applied to a particular circumstance, it can be subject to more than one reasonable interpretation. And if we've got 4 insurance companies, all of whom interpret it the way that the insureds do here, in our view, by definition, that must necessarily be reasonable, especially when it's one of the authors of the language at issue.
Thank you. Yes, sir, Mr. Judge.
Thank you, Your Honor. May it please the court.
Yes, sir.
Thomas Judge on behalf of Appellee Travelers Casualty and Surety Company of America. The court should affirm the district court's granting a summary judgment in Travelers' favor. It should do so because the undisputed material facts show that the shareholder claims for which Geld seeks coverage, shares, interrelated wrongful acts, as that term is expressly and broadly defined in the insurance contract, and or shares related facts, circumstances, or situations. The policy's unambiguously broad related claims provision then deems the shareholder claims to be first made when the antitrust claims were made, or when the circumstances underlying the antitrust claims was noticed to insurers. And that undeniably happened no later than early 2019, before the policy incepted.
Do you agree with the appellate's answer to what is a common nexus?
I don't, Your Honor. Nexus is a linkage. And later in the definition of interrelated wrongful acts, well, in the definition of interrelated wrongful acts, it includes a common nexus, wrongful acts that have a common nexus of any fact, circumstance, or situation, et cetera, or a series of causally connected facts, circumstances, or situations. Nexus means linkage, as I've read it in the dictionary. And there's a separate provision in the definition of interrelated referring to causal connections, causal series of facts, circumstances, and situations. And the fact is that however you look at it, however, you can look at it causally. They are causally connected. You can look at related facts, circumstances, or situations, and numerous courts have held that that term is by itself unambiguous and includes logical or causal connections. Applying either phrase from the definition, and they're not competing phrases, they're ors. The shareholder claims wrongful acts asserted therein, and those wrongful acts include, as they were necessary. You can read the amended consolidated complaint, and it affirmatively alleges the very antitrust violations at issue in the antitrust actions. It includes a chart of the anti-competitive price increases from 2013 through 2018, showing what was utilized. And that chart was utilized in the antitrust class actions.
So what do we do with the contract provision that says security claims are covered? Because the fact that the parties agreed to cover securities claims seems to suggest that these are separate and distinct from other kinds of claims. And securities claims, as your colleague points out, are always based on prior acts that were undisclosed and prior bad acts, presumably, like in this case. And it could be any number of types of litigation, not necessarily antitrust litigation here. And so the parties contracted for coverage of securities claims, and that's a separate provision. And so we have these two different provisions, and North Carolina law says, well, if the exclusion applies, then that's your burden to prove that it does. So what do we do with that?
So first of all, a securities claim under this policy is a type of claim. And the related claims provision applies to all claims. It doesn't distinguish between just claims and the subset of securities claims. It applies to all claims. And claims are defined to include, for example, a civil proceeding against any insured. So it doesn't matter who the insured is, whether it's the company or an individual, or whether it's a securities claim, it's a claim.
So what securities claim would be covered? If securities claims are based on, in general, they're based on failure to disclose or misrepresentations to shareholders, and they're misrepresenting something that happened that was bad in the past, and there was another lawsuit, I mean, when would this not apply?
It would not apply in so many circumstances, Your Honor. As you can see, this is one of the first instances where this has come up. Securities claims, yes, look at representations about past conduct, but there's not always a prior claim there existing. In fact, there hardly ever is. They're talking about, hey, in your disclosure, you restated your financials. And when you restated your financials, that gave rise to a securities claim. You said that you listed certain risk factors about what could happen in the future, but you already knew that you were experiencing problems with your supply chain. In all these circumstances, in the standard 10b-5 case that you see, there's not a prior claim sitting there on which the 10b-5 claim is predicated, like this one. Here, the securities claim is saying, you violated antitrust laws. It's not saying you didn't disclose the antitrust claims. It's saying you violated antitrust laws as established in these prior cases, and you concealed it from the public. And that very same allegation is in the antitrust claims, in the class actions. They said you were in a conspiracy, and you concealed this. And as you would, you're not going to tell the investing public, we're making great growth, which is what the securities class action was about. The securities class action was looking at, in the first instance, the registration statement filed in early 2017, which was then talking about revenue growth in 2016 and 15 and 14. And then in the 10K, which is also part of the 10b-5 case, it's talking about financial performance in 2016 and the growth that this company had experienced in the years prior, and explaining that growth based on pricing strategies and quality of products. And the securities plaintiff said, you failed to disclose that how you were actually experiencing revenue growth and profit growth was through your anti-competitive conduct, which has been established and alleged in these antitrust actions.
What I guess you, as the insurer, did you receive notice of the first antitrust action in 2016?
We did not. Travelers was not an insurer for Geld at that time. Travelers did not become an insurer for Geld until March of 2019, in the 1920 time period. And that's why
So was Travelers aware of these other suits when you all, when you came in March of 2019?
I don't think the evidentiary record indicates one way or the other, but assuming they were, that's why this policy language is so important. You get to rely upon it.
What do you do with your colleague's argument that policy language is ambiguous and therefore we construe, I mean, I look at the words, it is sort of a word salad, and it's difficult to determine what the difference is between the words that seem in and of themselves interrelated. So what do we do with the ambiguity in the contract that we are directed to construe against your client?
There is no ambiguity in the contract, Your Honor. The words say, for example, interrelated wrongful acts mean wrongful acts that have as a common nexus any fact, circumstance, situation, or transaction, cause, or series of causally connected facts, circumstances, situations, transactions, or causes. That's not ambiguous. Courts have applied that language in numerous other cases as unambiguous, and it is unambiguous.
But I think the argument is that in the Hunter versus Town the Town case, is that this is just the inverse of the Hunter case, because in that case, interrelated is not defined and related is defined. So how is this case different than the Hunter case?
Well, just calling it the inverse doesn't help or indicate that this language is in any way ambiguous. In this case, interrelated is defined. It's defined broadly, and it has effectively two different catch-alls. The first phrase refers to wrongful acts. The related claims provision includes interrelated wrongful acts, which then specifically defines, instead of interrelated not being defined, it lays out wrongful acts that have a common nexus of any fact, circumstance, situation, etc. Then it also has an or phrase, or the same or related facts, circumstances, or situations.
So that's where he's saying that related is not defined.
That's correct.
And so I guess, and I can ask him this, but I guess his argument is, based on the Town case, that case says that you have to define related and interrelated.
That's not what the Town case says. Town case says the only word they were dealing with was interrelated, and that word, undefined, had been applied by other courts to not include situations because unless it was defined more broadly, and the court references the language we have here, and it says that this language can apply when you have different claimants with different wrongful acts, but that are related. The court said there, if you had that language, we might find these claims related. And the court said otherwise, if interrelated is not defined, it's defined narrowly, and it does not encompass claims by different claimants for different wrongful acts. Here, interrelated is defined, and it's defined broadly in the way that the court references in Hunter. And here, you have separately related facts, circumstances, or situations, and the term related, unlike interrelated, is defined by courts consistently in a broad manner to include logical or causal connections. So you have interrelated, which courts have interpreted narrowly if it's undefined, but if it's defined, that definition is given its plain meaning as written. And we have related, which is an undefined term, but is a term understood in the case law as understood in common usage to embrace broadly logical or causal connections. So we cited multiple circuit courts of appeals holding that related is unambiguous when it's undefined and that it encompasses logical or causal connections.
Were those cases based on, it's just so broad. I mean, any fact. So you have the same company, the same management, that's a related, is that related? I am struggling with figuring out here what the limiting principle is and how we would write this in a way that would limit the cases that would fall under this exception.
So
And I
you
don't
would,
really think, I mean, it does seem, with the fact that we're even struggling with it, suggests that there's ambiguity.
well, Your Honor, if you apply it to the facts of this case, and you look at the allegations in the securities class action and how heavily they are reliant on the allegations, same allegations and the antitrust actions, they practically mirror each other. And then they similarly say, like the antitrust class actions, that Geld concealed its anti-competitive conduct from the public. There is shared facts. They are logically or causally connected. They're also just simply causally connected, because in order to lie about not having committed anti-competitive conduct, you had to actually commit that anti-competitive
So
conduct.
you're asking us to make a finding of fact, and we're on summary judgment, and we have to construe the facts in favor of the non-moving party. So why is summary judgment even appropriate if we're talking about facts here?
It's a fact-intensive inquiry, but the facts are entirely undisputed, Your Honor. The record is exactly as it is in the joint appendix. You can read the securities class action amended complaint. You can read the pleadings from the antitrust actions. And nobody's fighting about, when you read the briefs, other than what my colleague says up on the stand, when you read the briefs and you look at the joint appendix and you look at the facts alleged in these actions, they are intertwined, and you could not have the securities class action for this case absent the antitrust violations that are alleged in the antitrust actions. And so
But he has this argument that these directors, and I'm sure you heard me ask him earlier, the names, I'm trying to find the names, is it Beck and Mallard? That they've never been sued, and that this is tells you that this is a separate action, the officers and directors.
So 2 points on that. The related claims provision operates as to all claims. And it doesn't matter, as the courts have held in numerous cases, including in Stored Engineering from this court, and the WC case from this court, the Highwood Properties case from the Eighth Circuit, which was cited in Stort. The exact identity of the defendants is not controlling at all. And in fact, because the provision here relates all claims, and a claim is against any insured, furthermore, the antitrust actions were specifically and repeatedly referring to Mr. Hatchigian, who is the lead officer in the company. Additionally, in talking about the companies, Geld One Inc. and Geld One Holdings, and talking about them as alter egos, and talking about the companies acting through the directors and officers, identify these individuals. Furthermore, in the securities class action, where the pleading passed the heightened pleading standards of the PSLRA with the district court, the court had to find that adequate pleading of scienter by each of the individuals was alleged. And in fact, the court found that, saying, this is all about pricing. The pricing of your door skins and the pricings of your doors, and these are all the CEO and the CFO. They all had to know about pricing, and they made representations about pricing. So the court had no problem finding that they were adequately aware of what was going on in dealing with the consumers and engaging in anti-competitive conduct. So back to Judge Berner's question about, well, we have a securities claim. Well, let me get back to this on ambiguity. My colleague, when he talks about ambiguity, says, well, it can be in two situations. But he doesn't explain applying these phrases, which have been accepted as unambiguous by numerous courts. What is the interpretation you give them such that the shareholder claims are not related to the antitrust claims? What how is he reading the specific wording? They're not just, respectfully, it's not just a garden salad of words. They are words that have meaning. They have broad meaning.
Do they have different meanings, the words, from each other? All of them?
Well, they build on each other, and they're, in some respects, belt and suspenders. But, yes, so for example, you have a phrase about, you have applying to any interrelated wrongful acts, so claims for any interrelated wrongful acts, and then defining any interrelated wrongful acts. And then it's claims regardless of wrongful acts whatsoever, related facts, circumstances, or situations. So there's overlap, but they apply differently within the related claims provision. And then you have a separate, which you could consider for affirmance as well, a prior notice exclusion. And there was prior notice here, and the claim arises out of, or in any way relates to, circumstances that were specifically noticed by GELD to the preceding management liability policy tower. And contrary to what counsel says again and again, there's no evidence that any of the underlying insurers did any analysis like this. They were on both towers, and the only carrier who ultimately disagreed was Old Republic, and GELD settled with Old Republic. And I would further point out that while counsel talks about personal liability, there's no personal liability here. This is GELD seeking to collect additional money from travelers. All of the underlying claims were paid for either by insurance or by GELD. So it was either indemnified or by the company or by insurance. So,
Question, so I'm looking at the exclusion provision. So let's just say this court says that related facts should have been defined, and that makes that portion ambiguous. Does it matter that all claims, because here, which is a little different than in that Hunter versus Town case, it says all claims for the same wrongful act and interrelated wrongful acts, and here we have interrelated acts that are defined. Does that make a difference?
it does, Your Honor, because interrelated, you have a clause that you first would look at, would be the interrelated clause definition. Does that fit this situation? It does. Alternatively, you can look at the related facts or circumstances, and if the court were to find that ambiguous, it would be disagreeing with all the other circuit courts, and I think including this court, that has applied the term related as unambiguous when undefined. It is defined broadly to include logical or causal connections. So you would be disagreeing with all these other courts that related, by concluding that related when it's undefined is ambiguous.
Thank you.
Thank you, Your Honor.
Any other questions?
First of all, there's a related case in the world to stand for every single proposition. It is not true or accurate that all courts have found these provisions to be unambiguous. And there's two ways of looking at this. One is a finding of ambiguity, or the other one is simply to say that it's unambiguous, however, it's not related. Again, this is a matter of perspective because it's so malleable that it really becomes an open option for an insurance company in a given case to decide which way it wants to go.
So, the question that I asked him, if, in looking at this provision, because I'm looking at the provision in Hunter versus Town, in that case, it just says any related wrongful acts. Here, interrelated, wrongful acts. Here, it says all claims for the same wrongful act, any interrelated wrongful acts, or the same or related facts, circumstances, or situation shall be deemed to be a single claim. So if we were to agree with you that related is ambiguous, we still have the other provisions of this exclusion, same wrongful act and any interrelated wrongful acts. And if we were just to look at that, here, unlike in the Hunter case, interrelated wrongful acts is defined. And he's saying it's defined just as the court pretty much instructed in Hunter.
This is an exclusion that contains two standards. There's the interrelated wrongful act standard, and then there's the disjunctive term "or," which counsel emphasizes as saying if you don't like interrelated wrongful acts, then we can ratchet it back to any related fact or circumstance. If we're going to look at this from a perspective of any related fact or circumstance, then we render superfluous everything that came before. We have two different standards. One thing I think we can all agree on is that interrelated and related cannot mean the same thing in the same provision. That's a basic tenet of North Carolina interpretive law. These words must mean something different, which is really what Town of Mocksville is about. One of the concerns of this court in Town of Mocksville was that as these two provisions were defined by the district court, there was no daylight between the two. And here, below, this district court defined common nexus to mean logically or causally connected. In the same opinion, at the same joint appendix page, the court defined related to mean a causal or logical connection. The court defined these terms to mean exactly the same thing, and they coexist in the same provision. It's really a problem with this idea that the carrier gets sort of this moving target option. If you don't like the narrow, then we can slowly proceed to the broadest, any related act. At some point, that kind of language swallows the insuring agreement. Again, here we talk about dedicated, purchased, marketed securities claim coverage. Antitrust misconduct is not covered in these policies. Geldwen paid $124 million for its antitrust exposure. Geldwen paid the price. What Travelers seeks to accomplish here is to have Geldwen pay even more. And the fact that Geldwen Holding has the wherewithal to indemnify its officers and directors here doesn't really answer the insurance question, because in many cases, the employer will not have the money to indemnify its directors and officers. And again, Mr. Beck, Mr. Hashigian, these folks, this is the first time.
But this is the first time they were sued, but that's back to my question I asked you earlier, and I went back and looked at the JA. And it does, and there's that chart in there, I think it's JA 491 or 4, where on JA 500, where it says defendants by and through their officers, directors, employees, agents, and other representatives have engaged in a continuing agreement, understanding, and conspiracy in restraint of trade to artificially raise, fix, maintain, and stabilize the prices of interior model doors in the United States. Then on JA, I believe it's 492 through 93, if I'm correct, it names all of the officers and directors, including Mr. Beck and Mr. Mike Mallard.
These are folks that were alleged to have committed securities misrepresentations. They are not the individuals that were alleged to have engaged in antitrust conduct. Those folks are Orsino, Merrill, Mercier, and Fancher. Those are different directors. So when you read the securities complaint, absolutely, Beck, Mallard, Hashigian.
No, I'm referring to the direct, the suit from, I believe it's 2000, in a direct purchase suit that was previously, in that suit, they are the names on JA 5. If you look at the JA, the names are listed in there.
I will look at that, Your Honor.
Okay.
But one of the reasons why in the briefing you don't see these same references is because all Travelers was able to cite to was that generalized reference to the company's officers and directors. These folks are protected by securities claim coverage. They've never been sued before. It's asking a lot to swallow up a dedicated securities claim insuring agreement to merge every time that insuring agreement back into prior conduct that's not covered. Thank you.
Thank you. Thank you all for your arguments this afternoon. We will step down, but I will ask the clerk to adjourn court. And once again, if you can greet Judge Floyd up here on the bench, that would be great. Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.